When an attorney yells out, "Objection!" during the middle of a deposition, your attorney yelling out objection, what do? Do you have to continue answering the question that was just asked? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so now you brought a lawsuit against a careless doctor claiming that he was, in fact, careless. He was negligent. He departed from the standards of basic medical care. And as a result of that, you suffered significant harm and injury. Now, your doctor denies all of the allegations. Your case is now proceeding through the litigation process. And at some point during the course of your lawsuit, you will be asked to give answers to questions that are asked of you under oath. This is a process known as a deposition, a pretrial deposition. Lawyers also call it an examination before trial. In pre-COVID times, this would take place in your attorney's office. Typically, nowadays, it takes place on a Zoom video call. Your attorney will be on the call with you, along with the defense attorney, along with a court stenographer to record all of the questions that you were asked and all of the answers that you give. Did you know that the answers that you give represent your sworn testimony and carries the same exact weight as if you are testifying in court at trial in front of a judge and in front of a jury? So don't think for a second that just because this is being done somewhat informally on a Zoom video call that your answers don't have great significance. Actually, it does. So now let's get back to the question I raised at the beginning of this video. During the course of you being questioned, your attorney yells out "Objection!" in the middle of a question. What do you do in that instance? What do you do? Do you wait? Do you immediately answer? The answer is you have to wait a moment to see what your attorney tells you to do. Your attorney obviously has a problem with the question that's being asked. Your attorney has an absolute right to raise an objection, to let the attorney know who is questioning you that there's a problem. So what's the problem? There could be many different problems. It might be a way that the attorney asked the question, meaning that the attorney might have phrased it improperly. Maybe instead of asking a simple, straightforward question, the attorney has now combined one question into two. And now if you give a yes or no answer, there's no real way to understand, reading the transcript months or even years down the road, whether or not your yes or no answer referred to the first part of the question or to the second part. Lawyers call that a compound question, when there's more than one question joined together, and now the witness is going to answer it, and you don't know whether it refers to the first part or the second part. So let's say there's an issue about what my client complained of, right? And now the question is, hey, Mr. Jones, isn't it true that on July 5th you went into the doctor's office complaining of the following things? Well, what happens if the visit was really on July 6th, the day later? Now if he says yes, he made a complaint about the following things, but it wasn't on the same day. So the better way to do it is to say, hey, Mr. Jones, isn't it true that on July 5th you went into the doctor's office? Yes. And on July 5th, when you went to the doctor's office, isn't it true you made the following complaints? Yes. Okay, now we have clear, straightforward answers to simple, straightforward questions. Maybe the topic that the attorney is asking about is totally improper. So let's say it's a wrongful death case. And now the defense attorney says, did the person who died have life insurance? That is a palpably improper question. Now, why is it improper? Well, that's a topic for another video, and I've created videos about that specific topic. But the fact is, asking somebody whether or not they had life insurance had nothing to do with whether or not this particular doctor was careless. And as a result of that, that is a palpably improper question. Your attorney is going to immediately object, and what else? What else is going to happen? And as a result of that, your attorney is likely going to tell you, do not answer that question. So there are a couple of instances where the attorney can simply tell you, do not answer that question. So when you hear your attorney object, you have to wait a moment, and in most cases, at least in New York, in most cases, your attorney is still going to tell you to go ahead and answer the question. Why is that? It's because there are very few instances where an attorney can legally tell you not to answer a question. One of them is if something is totally off the wall and improper, like if the defense attorney turns around and says, hey, Mr. Jones, how many times do you beat your wife each night? What? That is a ridiculous question, having nothing whatsoever to do in the civil lawsuits involving accident cases, medical malpractice cases, or even wrongful death cases. Or if the question involves something that is privileged, confidential, such as you having a conversation with your attorney, and now the defense lawyer wants to know what the two of you talked about. That is not permissible. So your attorney will go ahead and tell you, do not answer that question. And you know what? The defense attorney knows better. Yet they're still trying to go fishing, trying to find information to use against you in your particular case. So why do I share this great information? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.